Hello, welcome back to A State of Affairs. This is California estate planning, bankruptcy, and tax attorney Ryan J. Casson here in Ventura County. Again, thank you for tuning in to my YouTube channel, A State of Affairs. Today, we're going to talk about transferee liability. Are you a landlord? If so, you need to watch this video. Do you have payors paying you funds, paying you money? You too ought to watch this video. Transferee liability can sneak up on folks very suddenly, out of the blue, even 2 or 3 years after the date of the transfer to you as the recipient. So as a landlord, maybe you are the transferee. So why are we talking about this? Well, this year, I've had a few meetings regarding folks in these situations that I'm about to explain, and every one of them never saw this coming. Again, the key concept that we are talking about is transferee liability. And in general, this issue, this lawsuit, frankly, can rear its ugly face against you in two contexts. One, bankruptcy, not for you. This is where the bankruptcy trustee comes after you. Again, this could be a couple of years after you were paid by your tenant, for instance, if you were a landlord, and also with the IRS in transferee liability, where property or funds or monies were transferred to you, and the IRS says, this transferor had unpaid taxes. Mr. or Mrs. Transferee, you need to pay us now that this transferor could not pay. You need to pay us for this underlying tax debt. So bankruptcy and IRS taxes. So there are a couple of defenses, but again, let me give you an example here. Let's say you are a California landlord and you have a tenant, and you get a check, old school traditional check every month, and you don't really think about whose name is on the check. You deposit the funds, the tenant pays on time. That's the end of it. You're a happy camper because your tenant pays on time, and eventually they move out. The lease terminates, the lease is up, you get a new tenant in there, or maybe you sell that rental property and you don't want to be a landlord anymore. Sometimes folks make that decision too, and all of a sudden you get a federal lawsuit served against you, or perhaps a state lawsuit that might end up in federal bankruptcy court. And you call somebody such as me and say, Ryan, what is going on? So we look at that, and it looks like, lo and behold, that person that was paying the tenant's rent to you as the real estate owner, as the landlord, it was a corporate bank account is what oftentimes happens. Perhaps it's the tenant's parent or their own company, and they're a sole shareholder, for instance, of their small corporation or their business. And either this person or a family member is oftentimes what happens. It's a parent oftentimes. They're tapping into the corporate bank account because why not? They think, surely it's I'm the sole shareholder. It's my money. Generally, no. And so if and when that corporation, if and when that company or business files for bankruptcy, as unthinkable as that might be, and again, you, the landlord, you have no clue what's going on because you never questioned this, but for whatever reason, that payor, that corporation, that company ends up in bankruptcy a couple years later. This does happen. The bankruptcy trustee, you better believe he or she's going to be going through the corporate bank accounts, the corporate records, the bank statements, and they're going to be highlighting and identifying all these transfers, looking for ways to claw the transfers back. So the tenant's rent check to you could potentially be clawed back to the bankruptcy trustee on behalf of the bankruptcy estate. The bankruptcy estate is then potentially distributed to the corporations or the business's creditors. Who are they? You don't know. Well, you are thrown into the fire here, and you have to deal with this. So a couple defenses are that generally the main ones are, number one, good faith. If you had lack of knowledge and you truly didn't know about it and there were no red flags. So this is not a situation where you can play the ostrich card and bury your head in the sand and roll your eyes or go wink, wink, and think that that's going to give rise to a good faith defense. That probably would not work. And, worst case scenario, that could be fraudulent as well. But the good faith defense boils down to lack of knowledge of financial distress of the payor. So the tenant that's paying the check to you, they cannot have been in financial distress to the best of your knowledge, and no fraud. And number two, the course of conduct, course of dealing, the ordinary course of business. So that's where we'd have to look at the prior couple years of the course of records between you and the payor, you and the tenant. What did the contract say? Did you follow contractual procedures? What was the ordinary course of dealing between the two parties? So sometimes that can be appropriate for a transferee liability defense in either a bankruptcy trustee case, again, where a bankruptcy trustee is coming after you in a state voidable transfer lawsuit and or federal bankruptcy proceeding. Litigation in bankruptcy courts are known as adversary proceedings. So that would potentially be a adversary proceeding that the bankruptcy trustee is bringing against you as the transferee. And so if we're talking about a couple years of payments, $2,000 a month for 12 months, $24,000, 2 years, that's almost $50,000. You've probably long spent that. The money is long gone. Yikes. But this is a serious situation that probably doesn't just go away. And oftentimes, generally, you're not going to want to try to resolve this and communicate with the bankruptcy trustee's office or the IRS, as the case may be, on your own. You're going to want to get sound, competent bankruptcy counsel or tax counsel, perhaps, to help figure out this transferee liability nightmare that so many folks, lo and behold, find themselves thrown into. So know your tenant, get paid on time and look at the name on the check. There's no particular name on the check rule per se. There's no litmus test, but there's really no downside in making sure that your tenant pays you from their personal bank account. If they say, well, it's my LLC, landlord, Mr. or Mrs. Landlord, well, it's my business. Well, again, this is a tangent for one moment, but and as far as business bank accounts go, and this is a whole nother presentation, but even with a sole member LLC or a husband and wife, as the case may be, if they're the two members of an LLC or a partnership or even two shareholders of a corporation, the assets have to be segregated from personal individual assets on the one hand and business assets on the other. Bottom line, the business bank account cannot be the owner's personal piggy bank or personal ATM. That gives rise to veil piercing the corporate veil. Same thing with LLCs and partnerships, and there's something called reverse veil piercing, way beyond the scope of this presentation, but veil piercing and alter ego liability or nominee liability. Alter ego means what? It's one and the same. It's the same entity. It's this LLC bank account, but the LLC member, you perhaps, you'd have been dipping into it just as though it was your personal ATM. That can very well give rise to alter ego liability. So if you're the landlord, you don't want to be taking a rent check from a tenant that is giving rise to alter ego liability. What if they file for bankruptcy or their small business files for bankruptcy? In this Chapter 7 trustee brings this alter ego liability action against the business owner, your tenant, and or you, by extension, transferee liability. The bankruptcy trustee wants to get paid. That's their job. They have broad authority under the bankruptcy code, as does the IRS. So with the IRS, there's a statute of limitations. Generally, The IRS has a certain amount of time to assess taxes against a taxpayer. So basically sending a tax bill. They have one more year after that assessment period lapses to go after a transferee. That might sound kind of complicated. So bottom line, that's a few years, and that's a big surprise. After a few years, after the taxpayer has transferred property for less than fair market value or due consideration to you, you get a scary letter from the IRS. Well, that's exactly what happens. So they have a relatively a lengthy period of time. Again, it's 1 year after the assessment statute period runs for them, the IRS, to assess taxes against the taxpayer. From that time, they have one more year to come after the transferee if that transferor had some type of unpaid tax liability situation with Uncle Sam. So there is a very clear Internal Revenue Code section for that. If you want to do some nerdy research here, that's Internal Revenue Code section 6901. 6901 deals with the transferee liability for unpaid taxes, and this could be income tax, estate tax, gift tax. So there's a recent case, folks, as I wrap up here, out of the U.S. Court of Appeals for the First Circuit, which is totally unrelated to the content of this presentation, but the underlying fact pattern is exactly what we're talking about. So this is the U.S. Court of Appeals for the First Circuit, again, just earlier this month, I believe, in July 2026, in Kayak Holdings, LLC versus IRS, KYICK Holdings, LLC versus IRS. That's a really interesting situation. Again, not related to our conversation here, our presentation, but that had to do with the IRS sending the notice about a tax issue, and it went to a different address, and there were some jurisdictional questions about appeals. Really interesting. But the underlying fact pattern had to do with a property owner that owned a whole bunch of commercial property, maritime property, and docking property, and boat slips and so forth. Really interesting. And so that individual transferred all of these assets into an LLC. The LLC members were the transferor's son and daughter. The IRS, for some reason, I don't know the exact factual background from the research that I've been able to see so far, but the IRS, again, for whatever reason, came after those transfers and came knocking on the LLC members' doors, the son and daughter of the transferor, alleging transferee liability, allegedly due to the transferor's fraudulent transfers in setting up and transferring this property to this particular LLC. So that is exactly what we are talking about. Couple years later, as the case may be, imagine being those LLC members in a similar situation as this example illustrates, where you get that very scary letter from the IRS alleging 6901 a liability as a transferee, and do you still have that property? Did you transfer it or sell it to another transferee? That gets very complicated. It is a big nightmare. So you can also see these situations pop up in winding up or closing down a business. Let's say you have a corporation, and for some weird reason, or maybe hopefully innocent on your part, in a total innocent oversight that you could resolve, but it's not always that easy. But let's say you were shutting down a corporation or some type of LLC business, and you had to have made employment tax deposits with the IRS, or estimated tax payments, some type of business-related or employment tax-related deposit with the IRS, and you hadn't, and you shut down the LLC, or as the case may be. And with your particular state, I'm here in California, let's say you, as the business owner, you file the appropriate corporate dissolution and wind down documents with the California Secretary of State, kind of forgetting about, or innocently, hopefully, not being aware of some outstanding employment tax or other corporate tax, as the case may be, liability. Somebody's still going to be on the hook for that when the IRS catches that oversight in the infamous IRS computer system, puts 2 and 2 together, which generally they will do. Those assets of the corporation or the LLC, as the case may be, were very likely distributed as dictated and in accordance with whatever the governing documents were. The governing document for an LLC, of course, would be the LLC operating agreement. It's going to dictate what happens upon the dissolution and the winding up of the LLC. And depending on who the LLC members or owners were, the LLC owners, again, are called members. Perhaps there was some property that was distributed to you and your spouse, or you and one of your kids, if they were the LLC members. And then you get that, again, very scary letter from the IRS alleging that you or a family member, as the case may be, or some transferee is obligated to turn over and allow the IRS to claw back the funds to satisfy unpaid taxes. So if you're a landlord, I think that's a very common example. You want to be careful about your payment sources from your tenants. And if you're a small business owner, you also want to be careful about segregating, bank accounts between that sacred business account as opposed to, on the other hand, your personal account. There's a big wall that should be between the two to minimize veil piercing, alter ego theory by the IRS, bankruptcy trustees that have nothing to do with you until you're thrown into this. Again, we're not talking about you filing for bankruptcy generally, or even judgment creditors that can, bring veil piercing, voidable transfer, fraudulent transfer, or alter ego theories to satisfy judgments. Again, that's outside the scope of this presentation. But bankruptcy trustees, the IRS, that's what we're talking about. If you need to analyze potential defenses, if you find yourself in this situation, hopefully the fact pattern that you present with, every case is different, of course, facts are always different. Hopefully that will give rise to a defense that will convince the bankruptcy trustee to go away, or maybe if they haven't, sued you yet, but you think it's coming through another player that's in the mix who is in there, and they contact you and say, hey, this is what's happening, and they might be coming after you too. You can get ahead of this sometimes, but if you get served and you're part of this state level, for instance, a California Superior Court voidable transfer action by the bankruptcy trustee, that could end up in bankruptcy court, or it was initiated as an adversary proceeding in bankruptcy court. Hopefully you can come to a negotiation. Maybe it won't be the full amount, or again, best case, you have that good faith defense, or that ordinary course of business, the ordinary course of dealings defense. But you want to avoid this. That's the long and short. Know your tenant, get paid properly in accordance with underlying contracts, and try to minimize any of these nightmares from happening. Again, folks, this is a little bit longer than I was anticipating, but I hope that this is productive for you. I hope that this is helpful. I think this is a really unique concept, a unique issue that estate planning attorneys traditionally don't really think about, and especially landlords. You care about getting paid, but there's a little bit more attention and consciousness that you can, and I think you should give to your tenants and in getting paid to minimize these situations that we've discussed for the past few minutes. Again, this is attorney Ryan J. Casson. I am a solo estate planning, bankruptcy, and tax attorney here in Ventura County, California. I hope this is helpful. And if you're in another state, please consult with an attorney or appropriate professional in your state if you need legal advice. And don't forget to subscribe to my channel here, A State of Affairs. Thank you all.